Imagine being asked to pay for a meal that you never ate. That's similar to asking sperm donors to cover child support. Today we'll dive into this perplexing scenario. So think about this. Jake, a kind-hearted individual, decides to donate his sperm to help those who are struggling to have children. It's an altruistic act, much like donating blood. Jake continues with his life, feeling proud to have helped others start their families. A few years later, however, he is stunned to receive a lawsuit demanding child support from a child conceived from his donation. Picture his shock and the ripple effects that this causes. This isn't just Jake's story. There are thousands of sperm donors out there whose generous actions have led to children being born to eager parents. So, are sperm donors responsible for child support? Can they be sued? If they do have to pay child support, what rights do they have as fathers? There have been cases where men who became biological fathers through donation were ordered to pay child support. But before you get too twisted up over this, know that these cases are rare and the donors often had a much closer relationship with the children and families involved. It's more challenging to argue for support if the donor has no connection to the child or family, and especially if the donor is not even known. Let me tell you a story. In 2014, a judge in Topeka, Kansas ruled that a sperm donor owed thousands of dollars in back child support 4 years after the child's conception. Want the good news? That case was later overturned. In many states, like Florida, laws state that a sperm donor for artificial insemination is not considered a parent and cannot be held responsible for child support. Similarly, the Supreme Court of Georgia has ruled that biological paternity does not create a support obligation in the case of artificial insemination. So what happens if the laws are not clear? The idea of making a donor pay child support seems absurd because sperm donation is intended as an act of generosity with the understanding that the donor has no further obligations or rights regarding the child. This understanding is crucial for assisted reproductive technologies, allowing many to achieve their dreams of parenthood. So should donors like Jake be liable for child support? Absolutely not. Treating donors as financially responsible parents misinterprets their goodwill and it sets a dangerous precedent. It could deter future donors and it raises questions about the donor's rights. If they're financially responsible, do they also get custody rights? Do they also have a right to parenting time? Are we really prepared to redefine parenthood in that way? The key issue here is intent and agreement. Donations are made to help, not the parent. Legal frameworks in many states recognize this, ensuring that donors are not liable for child support if the donation is through licensed clinics. This protects the donor's intent and also protects the recipient's right to parent without expected claims by the donor. For those advocating for donor responsibilities, consider this. If we impose financial obligations, shouldn't we also discuss rights? It's a slippery slope that you don't want to go down. Granting custody rights to donors could complicate the act of donation, turning it into a legal battleground, which will be disastrous for all involved. So, for men in Georgia who are considering sperm donation, or for anyone curious about sperm donation, remember that the law in Georgia and most other states protects you. It's always wise to understand the legalities in your state, so talk to a good family law attorney if you have any questions about this.
Thank you very much.
Hey, thanks for watching. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos and leave us comments and ask us questions. Also, join our Facebook group at Georgia Divorce and Custody, and I'll see you again on the next video.